the telecom giant's NSA spying partnership and privacy violations. In the summer of 2013, a 29-year-old NSA contractor named Edward Snowden would expose one of the most sweeping surveillance operations in American history, and at the center of this digital dragnet sat Verizon Communications, the nation's largest wireless carrier. What emerged from Snowden's leaked documents wasn't just evidence of government overreach, but a chilling portrait of corporate complicity that had been quietly operating for nearly a decade. Verizon, the company that built its reputation on the simple promise that customers could hear me now, had been systematically handing over the private communications of millions of Americans to intelligence agencies, while simultaneously charging those same customers some of the highest rates in the industry. The scandal would reveal how America's telecommunications infrastructure had been weaponized against its own citizens, with Verizon serving as both gatekeeper and willing accomplice in what would become known as the largest domestic surveillance program since the founding of the Republic. The roots of Verizon's surveillance partnership stretch back to the chaotic aftermath of September 11, 2001, when fear and patriotic fervor created the perfect storm for expanded government powers. The PATRIOT Act, rushed through Congress just 45 days after the attacks, dramatically expanded the government's surveillance authorities, but it was the secret interpretation of Section 215 that would prove most crucial to Verizon's later cooperation. This obscure provision, originally intended to allow the FBI to obtain business records relevant to terrorism investigations, was secretly reinterpreted by the Foreign Intelligence Surveillance Court to authorize the bulk collection of all American phone records. By 2006, this legal framework had evolved into a comprehensive data harvesting operation, with Verizon serving as the primary conduit for what the NSA internally called the Metadata program. The company's executives, bound by strict secrecy orders and facing potential criminal penalties for disclosure, found themselves operating a parallel business model where customer privacy became a commodity to be traded for regulatory favor and protection from government interference. The mechanics of Verizon's data-sharing operation were both sophisticated and invasive, encompassing far more than simple phone records. Under the NSA's PRISM program, revealed in Snowden's documents, Verizon provided real-time access to customer communications, including phone calls, text messages, internet traffic, and location data from mobile devices. The company maintained special secure facilities, staffed by employees with security clearances, dedicated exclusively to processing government data requests. These operations were funded not by taxpayers, but by Verizon customers themselves, as the company built the costs of compliance into its rate structure while maintaining some of the highest prices in the telecommunications industry. Between 2006 and 2013, Verizon collected over $386 billion in revenue, while simultaneously operating what amounted to a private intelligence service for the federal government. The company's cooperation extended beyond simple compliance with court orders to include proactive assistance in developing new surveillance capabilities, with Verizon engineers working directly with NSA technicians to optimize data collection and processing systems. The legal architecture supporting this surveillance partnership was built on a foundation of secret court orders and classified legal interpretations that effectively neutered traditional privacy protections. The Foreign Intelligence Surveillance Court, operating entirely in secret with only government attorneys present, issued blanket orders requiring Verizon to provide all call detail records for communications wholly within the United States. These orders, renewed every 90 days like clockwork, covered not just suspected terrorists or criminals, but every single American who used Verizon's services. The company was prohibited from disclosing the existence of these orders, creating a bizarre legal paradox where Verizon was simultaneously required to violate its customers' privacy and forbidden from telling them about it. Court documents later revealed that Verizon received over 1,500 national security letters between 2003 and 2012, each demanding customer information and carrying automatic gag orders that prevented any public disclosure. The company's legal department, working closely with government attorneys, developed streamlined procedures for processing these requests that treated constitutional privacy protections as bureaucratic obstacles to be efficiently circumvented rather than fundamental rights to be protected. The scope of data collection under Verizon's partnership with intelligence agencies was breathtaking in its comprehensiveness and chilling in its implications for American privacy. NSA documents revealed that the agency was collecting metadata on over 3 billion phone calls daily, with Verizon providing the largest single source of this information. This metadata included not just phone numbers and call duration, but also location information, device identifiers, and detailed routing information that could reveal intimate details about Americans' daily lives, relationships, and activities. The NSA's own internal documents describe this information as allowing analysts to determine communities of interest and map social networks with extraordinary precision. Verizon's mobile network, covering over 300 million Americans, provided the government with real-time location data for millions of devices, creating what privacy advocates described as a digital ankle bracelet for every American carrying a cell phone. The company's Internet Services division provided similar access to email communications, web browsing histories, and data usage patterns under various classified programs, with code names like XKeyscore and Muscular. While Verizon was secretly cooperating with the largest surveillance operation in American history, the company was simultaneously engaging in pricing practices that critics argued exploited its customers' captive position in an oligopolistic market. During the peak years of the surveillance partnership from 2006 to 2013, Verizon consistently maintained some of the highest prices in the industry while delivering what consumer advocates characterized as mediocre service quality. The company's average revenue per user climbed from $47 per month in 2006 to over $56 per month by 2013, even as the actual cost of providing telecommunications services declined due to technological improvements. Verizon justified these price increases by citing network investment and improved service quality, but internal documents later revealed that significant portions of the company's capital expenditure were actually devoted to surveillance infrastructure required by government contracts. The company received direct payments from intelligence agencies for its cooperation, but these payments, estimated at over $300 million between 2001 and 2013, were dwarfed by the costs of compliance, which Verizon simply passed through to consumers in the form of higher rates and various administrative fees. The revelation of Verizon's surveillance partnership triggered a cascade of legal challenges and public outrage that would ultimately reshape the telecommunications industry's relationship with government surveillance. The first major crack in the secrecy wall came in June 2013, when The Guardian published a top-secret FISA court order requiring Verizon to hand over all call records to the NSA, based on documents provided by Edward Snowden. The order, dated April 25, 2013, and valid until July 19, 2013, provided the first concrete evidence of the bulk surveillance program that privacy advocates had long suspected but could never prove. Within hours of the publication, Verizon's stock price dropped by 3.6% as investors grappled with the potential legal and reputational consequences of the company's cooperation. The revelation prompted immediate congressional hearings, with lawmakers from both parties expressing shock and outrage at the scope of the surveillance program. Senator Rand Paul filed a class-action lawsuit against Verizon and the NSA, claiming that the bulk collection program violated the Fourth Amendment rights of millions of Americans. The lawsuit eventually grew to include over 400,000 plaintiffs, making it one of the largest constitutional challenges in American legal history. Corporate accountability for Verizon's role in the surveillance program proved frustratingly elusive, highlighting the challenge of holding private companies responsible for secret government partnerships that operate outside normal legal and regulatory frameworks. Despite overwhelming evidence of the company's cooperation with bulk surveillance programs, Verizon faced no significant financial penalties or criminal charges, protected by the same legal framework that had authorized its cooperation in the first place. The company's executives, including CEO Ivan Seidenberg and later Lowell McAdam, maintained that they had simply complied with lawful government orders and had no choice but to cooperate with intelligence agencies. This defense proved legally bulletproof as courts consistently ruled that companies could not be held liable for following court orders, even if those orders were later determined to be unconstitutional. However, the reputational damage was substantial, with consumer advocacy groups organizing boycotts and competitors using Verizon's surveillance cooperation as a marketing tool to attract privacy-conscious customers. The company's customer satisfaction ratings, already mediocre, declined further as consumers expressed anger about paying premium prices to a company that had secretly betrayed their trust. The long-term consequences of Verizon's surveillance partnership extended far beyond the company itself, fundamentally altering the relationship between American citizens and their telecommunications infrastructure while highlighting the dangerous intersection of corporate power and government surveillance capabilities. The Snowden revelations triggered a massive shift in public awareness about digital privacy, with surveys showing that over 60% of Americans changed their online behavior in response to learning about surveillance programs. This shift had profound implications for the entire telecommunications industry as consumers began demanding stronger privacy protections and greater transparency about government data requests. Verizon, along with other major carriers, was eventually forced to publish annual transparency reports detailing the number and type of government requests for customer data, though these reports revealed only a fraction of the actual surveillance activity due to ongoing classification restrictions. The company invested heavily in privacy-focused marketing campaigns and technical measures designed to rebuild consumer trust. But internal surveys showed that a significant percentage of customers remained skeptical about the company's commitment to protecting their privacy. The regulatory and legal landscape surrounding telecommunications surveillance was permanently altered by the exposure of Verizon's partnership with intelligence agencies, though meaningful reform proved slow and incomplete. The USA Freedom Act, passed in 2015, officially ended the bulk collection of phone metadata and required intelligence agencies to obtain more specific court orders for customer data. But critics argued that these changes were largely cosmetic and left the fundamental surveillance infrastructure intact. Verizon continued to receive thousands of government requests for customer data each year, though the company was now required to report aggregate statistics about these requests in annual transparency reports. The Federal Communications Commission, under pressure from privacy advocates, implemented new rules requiring telecommunications companies to obtain explicit customer consent before sharing location data with third parties. But these rules contained broad exceptions for law enforcement and national security purposes. Perhaps most significantly, the scandal highlighted the inadequacy of existing privacy laws in the digital age, prompting ongoing debates about the need for comprehensive federal privacy legislation that would give consumers meaningful control over their personal data. The European Union's General Data Protection Regulation, implemented in 2018, created new compliance challenges for Verizon's international operations and served as a model for privacy advocates pushing for similar protections in the United States. Today, more than a decade after the Snowden revelations, the fundamental tension between national security surveillance and consumer privacy remains unresolved, with telecommunications companies like Verizon continuing to operate at the uncomfortable intersection of corporate profits, government demands, and constitutional rights.